See if we can spotlight them. Okay, wonderful. Okay, and there we have good morning, Niamh. Happy to see you.
Good morning.
And good morning. And do we also have Marie-Ève? There we are. Good morning. So good to
Hello.
see you. Okay, well, wonderful. We're going to kick off this session. So we've chosen to start this expo with regulation. It was not an accident. It's because when we're really serious about intentional design, where the architecture of these platforms strengthen rather than fracture social cohesion, we need to look at what the incentives and accountabilities are. And one of the most powerful levers that we have between companies and the markets is regulation. The Digital Services Act, which is the regulation that governs digital platforms in the 27 EU member states, is one of the most important initiatives underway, not only because of its scope, but also because it has been deliberately focused on moving beyond just content takedowns towards looking at how the platform is actually built. And we're going to hear a little bit more about what that means and what levers the DSA has been able to use looking at platforms like Meta, TikTok, and X. And our two guests today for this session are right at the center of this shift. Niamh Hanafin is the Assistant Director of International Affairs at Ireland's media regulator, Coimisiún Meán, where the major headquarters are headquartered and it is thus one of the major DSA enforcement bodies in Europe. And Marie-Ève Nadeau is the head of international affairs at the Five Rights Foundation, which is really one of the leading organizations that is working across dozens of jurisdictions across the world to advance rights respecting design, including regulation for children globally. And before I launch my first question, I want to say that many of us joining, particularly this session, are coming from places that are either lightly or not at all regulated. And so I encourage us to really listen with this curiosity about what's working, in places that are more regulated like Europe. And when we look at other jurisdictions, what are the things that we want to really take forward in terms of what regulation can do best? So Niamh, let's kick it off with you. I'd love for you to try and really illustrate concretely in what ways is the DSA's work underway focused on platform design or specific pieces of the architecture?
Absolutely. Thanks so much, Lena, and really lovely to be here. Let me just talk about the DSA for a moment. You've given a really good overview of it, Lena. It is a very complex legal instrument. It's an instrument that has given new rights to users in the online environment in the European Union, and really is intended to ensure that people have greater safety, transparency, and control over their online experience. And it's also designed to ensure that these rights can be easily exercised and accessed through the platforms that we're using every day. And to your point, Lena, while the DSA is an EU rulebook, what makes it interesting and worth paying attention to is that it's trying to tackle the way digital products are designed. And then how that design sort of shapes our behavior, our choices, and our well-being online. And it's attempting to address that from a systems level rather than looking at sort of individual pieces of content. So I think wherever you are in the world, enforcement of the DSA and the outcomes of that really does merit close attention if we're trying to kind of understand the impact of regulation on product design. So I think the other thing I would say about the DSA, and this is a criticism that we get a lot from external parties, it has taken a long time for the DSA for implementation to kind of start to reach cruising speed. It's been a very complex regulatory instrument to set up, but we've seen recently a fairly marked increase in enforcement actions, both by digital services coordinators like ourselves and the European Commission. So as you say, we are the media regulator in Ireland. We have 16 of the 26 very large online platforms and search engines headquartered here. So when we enforce, that enforcement has implications well beyond us and for the entire region. So in any case, what I want to do is just highlight quickly two investigations that are ongoing to illustrate where we're at and where we're starting to see the DSA really take aim at some of those central design features of the regulated entities that you've been talking about. So the first is in fact an investigation that has been opened by Coimisiún Meán, by ourselves, into Meta's Facebook and Instagram services, and it's looking at how the recommender systems and user interfaces are designed. So it's focusing on whether users can easily and at any time choose a feed that is not based on profiling. So that's a requirement of the DSA under Article 27. And it's also looking at whether the platform's designs are using dark patterns. So these are the kind of manipulative interface choices that nudge us in ways that normally and ordinarily we would not go. And that is in violation of Article 25 of the DSA. So just a couple of observations about these two investigations. We just opened them in recent weeks, so they're very new, they're ongoing, and outcomes are going to take some time. But I think just to highlight that they are very much focused on interface design and recommender system design. So these are not peripheral features that we're looking at. These are the sort of fundamentals to engagement and advertising models, user experience, and it really sort of reflects the way the DSA is intended to work, looking at how platforms are designed and operated rather than this sort of content model. And then secondly, we're looking at Facebook and Instagram interfaces and whether they use these so-called dark patterns that steer users away from exercising their right to choose this non-profile feed. And again, we're looking at the heart of the design. This is about navigation flows. It's about default settings, prominence of options. Like, these are not neutral choices, as you say. These are very deliberate design choices by providers of these services to orient users in a way that benefits them. And I mean, ideally, companies should be looking at this at the design stage, but and eventually that's the kind of behavior that we would like to ultimately see, so really looking at default settings, menu hierarchies, and this kind of thing. So that's the first example I would raise. The second example is the European Commission's TikTok investigation. We just had preliminary findings of this investigation in February, so it is also ongoing. We don't have a final decision, but just again to look at the scope of this case in the framework of this conversation, there are a couple of very relevant aspects. I think the first, again, is that the Commission is scrutinizing the core design features. So it's looking at features like infinite scrolling, autoplay, push notifications, and TikTok's. Well, I mean, we know how effective their recommender system is. It's incredibly personalized. It's extremely compelling. And these are not the optional add-ons of TikTok, right? This is what makes TikTok the system and the success that it is. And it's core to their business model. And then the second thing I would say is that this investigation is putting a very strong emphasis on the fact that the European Commission considers the addictive nature of these features to be a systemic risk. So this really elevates core aspects of design as being deeply problematic from a systemic risk perspective. And so based on that categorization, that allowed TikTok or the Commission to preliminarily find at least that TikTok has or may have failed to assess how these features can harm users' physical and mental well-being, and that's particularly true of children and vulnerable adults. So this potentially will be setting some very important precedent. In the future, we will be seeing potentially platforms being held to account, not just for what's happening on their services, but for how those services are designed. The only other thing that I would just add in relation to the TikTok investigation is that it relied very heavily on third-party evidence and scientific research. Civil society organizations and others have contributed really significantly to this investigation. So I think just in terms of the complexity of the regulation, this also highlights that, we are just one stakeholder and we really do rely on some of those other third-party DSA stakeholders to make this work.
Thank you so much, Niamh. So, Marie-Ève, when we look globally, we see that there is an enormous amount of momentum around child online safety, protection of minors online. And I'd love for you to share to what degree some of these recent initiatives, we're thinking Indonesia, Brazil, but maybe some other places, are in fact also seeing that it's the design and architecture of the platforms that's important to shift in order for a greater protection of minors online.
Yes, thank you so much, Lena, for the invitation. It's really great to kick off the Global Expo today, especially as an organization that has been working across the world to ensure that technology is designed with children in mind. So after Niamh has laid what strong regulation can deliver in practice regarding oversight, specifically of design and architecture, I want to respond to the question, indeed, Lena, by zooming out a little bit and about how we got there. Because indeed, as you've laid in the introduction, over the past decade, child online safety has been reactive. It's been around responding to harm. And it's long been retrofitted or diluted behind closed door. But there has been indeed a growing understanding and awareness of how those risks that children face are amplified indeed by the business models, by the design choices that shape behavior, that drive engagement, and also maximize time spent, as, for instance, the earlier work that we did at Five Rights in disrupted childhood. And indeed, as Niamh has mentioned, that was the focus of investigation in the Digital Services Act, where engagement-based recommender systems, manipulative design choices, algorithmic amplification, profiling, and extractive data practices. These are all choices that are currently putting children's rights, children's safety at risks, and they make it difficult for children to get off their screens. But as it was also laid in the introduction, it's also what's fueling gender-based violence. It's also what's polluting the information ecosystem at scale and amplifying polarization. So in the past decade, we've really seen a shift where it has become very clear that children's safety can not only depend on parents trying to navigate hundreds of privacy policies, settings, or controls, and that digital literacy that only puts a burden on children to know better, to make better choices in environments that are skewed and working against them are not enough. And indeed, we've seen this shift moving from reacting to harm towards proactively addressing and looking at the design of digital services themselves. And Niamh has been painting how the Digital Services Act has been implemented and it's starting to be enforced in practice. We've also long seen from a data protection and privacy perspective in the UK with the age-appropriate design code that has been demonstrating how to demonstrate privacy and age-appropriate design and default. But indeed, we've seen recently Brazil and Indonesia also moving towards a growing momentum towards enforcing duties on platforms and services. But moving beyond Asia and Latin America, we've also seen, for instance, in the African Union, the child online safety and empowerment policies. And we have recently published a recent thesis that is in the notes of the call, an international blueprint for digital environment with children in mind, where we really highlight how those recent regulatory development, and we're looking at more than 50, have been focusing and moving at upstream protection and have been putting this accountability on platform architecture, on the design, and also embedding children's rights and safety into the design and default, and that have been looking at proactive risk mitigation and looking at how to anticipate and prevent harms. And indeed, as Niamh mentioned on the Digital Services Act, also putting scrutiny and oversight of algorithmic amplification, engagement-based recommender systems, and addictive and manipulative design. I think one of the core emerging principles that has been emerging globally has been that child online safety cannot be only bolted on through warnings, through reporting tools, and parental controls. And we are also seeing that regulation can lead companies to change their practices and account for the presence of children. Now, I'm sure many of you are also aware that with the increasing realization of arms, we're also seeing growing attention around bans, around restrictions and age limits. And it's important to note that age restrictions or age limits are not new, and they have existed for decades across many industries. We've seen, for instance, for a long time, age 13 for the consent of personal data, despite very poor implementation of enforcement, but it can only be a very tiny part of the solutions, as it can help prevent children from accessing the worst of places that are not for them, or target companies that do not comply with the law. But they do not on their own tackle the systemic failures that we've been talking about in how digital spaces are designed, and they do not create better, safer, or more rights-respecting spaces. And that's where I would encourage that we shift our focus on looking at the design and architecture, because children do not only need protection from spaces, but they also need better spaces that are designed with their rights and safety in mind.
Thank you. Thank you, Marie-Ève. And I was struck with the latest report that came out evaluating what kinds of platforms changes have been made over the last 2 years. This is a follow-up from the work that was done from 2017 to 2024, now looking at the last 2 years across 70 platforms, highlighting 108 changes in different features, tools, product. It's worth looking into it, but it was such, again, a reminder that regulation is a key incentive for companies to make choices, either to better enforce their own policies or to decide to explore other options. Wonderful. So Niamh, let's just come back to you. And you mentioned that some of the investigations are indeed sparked or enabled or supported by information that's surfaced from other stakeholders. What would you like to share is perhaps the challenge area, or the place we need to most focus if we want regulatory efforts to perhaps live up to their best promise?
I mean, there's a couple of things I would probably flag. I think the DSA, because of the complexity of it and because of the fact that it has built-in stakeholders beyond regulators, right? I mean, they are written into the legislation, including civil society organizations, trusted flaggers, vetted researchers, out of court dispute settlement bodies, etc. Right. So there's there's an ecosystem baked into the regulation, and that ecosystem is still building, and it's going to take some time to build, and the DSA needs that to reach that sort of cruising altitude where these various stakeholders are connected in a way that they're reinforcing each other, right? And they're understanding each other, and there is a sort of a flow of information around regulatory priorities, the way that the DSA and the Digital Services Board particularly is making decisions on how the DSA should be implemented in a sort of a harmonized way. So I would highlight that as being, I think one of the big current challenges that we see. And at the moment, that is a system that is still being put into place.
Thank you very much. Marie-Ève, maybe offer us again a perspective of what are the opportunities and perhaps the challenges looking beyond Europe now and beyond, into Africa, Asia, Middle East, Latin America? What is important for different stakeholders, including those joining us online, to really keep in mind, particularly given how in focus this question of online safety for minors is across the world today?
Yes, so we're definitely seeing regulation as being a first step in setting expectation, in defining responsibilities, and signaling what is the foundation. So children rights, human rights, safety, and corporate accountability. And indeed, you touch also to the recent publication of the Digital Future for Children. I think what we have seen around the first passing of the age-appropriate design code a little bit more than 5 years ago has been how it has been indeed leading to change in companies' practices. And then, of course, I think one of the things to note perhaps is the importance on focusing on the design and architecture and resisting this move from companies that will try to make it an issue of user empowerment or digital literacy, ultimately allowing risky design unchallenged. And perhaps just mentioning some of the challenges is, of course, we're seeing technology moving fast with, for instance, generative AI posing certain challenges. And that's where it's also important to have flexibility to address these evolving harms rather than playing catch up.
Wonderful. Thank you very much. Let's take this question from Helena from Build Up to Niamh. What is your view on the Spanish government's new hate and polarization footprint, or more in general, what's your view on national governments within the EU imposing their own sanctions on platforms, whether this supports or undermines DSA sanctions based on risk assessment? Any thoughts there, Niamh?
Yeah, there probably isn't a huge amount I can say from our position as a regulator. Obviously, our job is to implement the law, and we don't really get involved in the sort of political discussions around it. But this, along with any other new national level legislation, has to go through the European mechanism to assess whether it is aligned with European legislation, and then that's a process that really would, some of these potential like incoherencies or inconsistencies or conflicts between legal instruments can be detected, but that process really just has to play out, and after that it's a political decision what happens to these efforts at the national level. It's not the only initiative that we're seeing nationally that will need to align with European law.
Thank you. Thank you so much. Mariam, I want to come back to you. We've talked over the last few years about efforts to enable civil society. We've worked together in Africa to be part of advancing a type of regulation which is rights respecting, which is not empowering governments to overreach, censor, take down political opponents, because this has been one of the real obstacles in many parts of the world to real partnership, even with the intention of trying to protect kids online, to empowering regulation. And those questions have not been absent in Brazil and Indonesia as well. What might you want to say about, again, where you've seen that line being drawn so that we can give sufficient empowerment to regulators? Perhaps it's drawing on some of the things Niamh said about a multi-stakeholder architecture, but other things that could really clarify how civil society can participate in this process in a way that's really true to their values and principles.
Yes, of course. And it's definitely been a growing challenge across the world to ensure that indeed laws and regulation is delivering and is not indeed entrenching and infringing on violation on human rights. And indeed, I would say that one of the starting point is we have well-established international human rights law, and we've seen indeed in many places in the world how it has been the foundation of having tech accountability and tech governance more broadly to ensure that it's not only there to protect children, but also there to enable broader human rights, I would say. And it's where we have been holding companies accountable to respecting those rights, but also to mitigate the harms. And looking at system design allow indeed to not police content, as it was mentioned at the beginning. It allows not to just react on the content that we might not like politically, but instead focusing on how this content is made viral, how it's made to drive polarization. And indeed, looking at system design, where we have seen for a long time how those measures and those choices from companies that are benefiting, and I'm sure that will be a topic that will be more covered today, but it's been really allowing to shift the conversation indeed from a more right-respecting approach, and that is grounded in, and that allows as well to ensure that it's also respectful of human rights more broadly.
No, and it's interesting because I think in some ways there may still be an ongoing friction, if we can call it, or continual drawing of the line of what kind of freedom of expression is appropriate for this country or that country, and where does that enable or disable a type of regulation of these spaces. So I think just want to again point out that Five Rights has an enormous amount of resources on their website, a blueprint. They have also recently done things, as Marie-Ève was pointing out, about AI, and have particular perspectives about the relationship between children and generative AI. And maybe, Niamh, I'll just come to you. If you mentioned that technology is moving quickly. Is there any last thing you want to share about, again, what we should be paying attention to when we look over this coming year with what the DSA might be paying attention to?
Sure. I mean, we've been very clear for 2026, protection of minors is one of our key thematic priorities. So, that what we're seeing in practice is we've seen already the investigations opened against the 4 large adult content platforms by the European Commission. Other DSCs at the national level are also trying to understand what similar smaller sites below threshold might be in their jurisdictions, and trying to really map that out and understand what next steps can be taken. I mean, obviously, the access of minors to social media and other online services is, I think, just going to be a continuing debate. We just had a report released by a governmental committee here in Ireland, which I think was actually quite nuanced in terms of what it is trying to highlight, but very much looking at those issues of design, but ensuring that there is a sort of a child's rights approach embedded into any actions that are taken in regard to young people's access to and children's access to services online. I think we really need to watch the AI space. I think with the Digital Fairness Act, I beg your pardon, coming into play now, we know that there's also going to be a very strong slant towards protection of minors, but also looking maybe in more depth at the challenges of dark patterns and some of these other newer sort of AI features and functions that we're seeing being embedded into some of these larger services.
Wonderful. Thank you very much. Any last words you'd like to offer, Marie-Ève?
Yes, thank you so much, Lena. So I just want to quickly highlight one of our most recent pieces on investigation that will come out in the next couple of weeks, where we've been looking at the cases of platforms' safety commitment in the global majority. And we've been looking at the case of TikTok in Mexico, where we've seen where the features that are currently prohibited under the Digital Services Act that incentivize compulsive engagement by paying users to be on the platform and were prohibited were found to be given to adolescents and children in Mexico. So we're really seeing that there is an impact of regulation because we're seeing those being prohibited in the EU, and that harms is not inevitable and can be addressed.
Thank you so much. Thank you so much. I find that kind of research just so incredibly revealing because it brings to the surface that sometimes we know the harmfulness of a design pattern, and yet without some type of further accountability, sanctions, etc., we're not necessarily seeing that goodwill all on its own by the tech companies. So again, I just really want to thank you for being available for us today. Again, really encourage you to check out the resources document that Trini's been posting in the chat with more readings about 5 rights and about the ongoing large work of the DSA. Thank you both so much for being with us today. Thank you so much.
Thank you, Lena.
Thank you.